Hello, everybody. Hello. Little bonus live. Hello, hello, hello. Welcome in. Welcome in. Good to see you all. I have been running around, and so I've been able to track down the articles of impeachment that were filed today. So, because I've got something different for my live tonight, I thought I would come on. Hello, hello. And go through these now. So, good afternoon. Good afternoon. Hello, everyone. Yes, we have two, everybody. We have two sets of articles of impeachment here. Two sets. And it's a pretty big deal. It's a pretty big deal. Yes, I know. It is very exciting. So welcome in, everybody. Welcome. I thought I would pop on and go through this real quick. They're long enough, but there's some pretty serious documents here. The first articles of impeachment, they're still hot off of my printer here. So let me split them up here into two batches. We have the first one against Clarence Thomas, high crimes and misdemeanors here. And then the second one is against Justice Alito here. So we've got high crimes and misdemeanors. So we have two sets of articles that have been filed. Yes, hello. So it's hard to tell exactly when all of this went down as far as when they were technically filed, but I've just been able to get my hands on them just now. So let me go ahead and read through these, everybody. Oh, thank you so much. Let's read through these. I think they're pretty well written. We will see how things proceed from this point. But with our Senate, the way it is, pretty slim majority when it comes to both the House and the Senate. So, yes. So, so this was filed by AOC in the House of Representatives. So Representative Ocasio-Cortez has filed. She's filed against Justice Thomas as well as Justice Alito. I think we've had Supreme Court justices. I think we had one before who was impeached. It was a very, very long time ago, and I don't think they went through the full process. I don't think they were convicted, but certainly in any kind of recent history. Well, either way, I think it's still pretty good. Hello, good afternoon. I think it's still good to have a record of it. I think we're building a record. Sometimes I think that can be incredibly useful to do. So let's go ahead. I will dive right in, everybody, so that I can read both of these articles set out for you. Now, again, nothing has passed at this point. We just have the filings now, but she has filed against Justice Thomas as well as Justice Alito. So both of those have just been filed. Well, we'll see what happens. We'll see. I feel like if the Refrigerator Freedom Act can make it out of committee, it's possible the impeachment articles can as well. So, will it go into their personnel file? Who knows? All right, let's look and see what she's got to say, everybody. In the House of Representatives here, we've got resolution impeaching Clarence Thomas, Associate Justice of the Supreme Court of the United States, for high crimes and misdemeanors. Resolved that Clarence Thomas, Associate Justice of the Supreme Court of the United States, is impeached for high crimes and misdemeanors, and that following articles of impeachment be exhibited to the United States Senate. Articles of impeachment exhibited by the House of Representatives of the United States of America in the name of itself and of the people of the United States of America against Clarence Thomas. Let me just make sure we can all see the page here. Here we go. Just going to bump this down a little bit. Associate Justice of the Supreme Court of the United States in maintenance, I'm sorry, everyone, forgive me, in maintenance. Oh, what just happened there? Too much coffee. In support of its impeachment against him for high crimes and misdemeanors. So here's Article 1, a failure to disclose. Hello, Sarah. Good to see you. Failure to disclose. The Constitution provides that the House of Representatives shall have the sole power of impeachment, and that all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Citing law here. Require judicial officers, including associate justices of the Supreme Court, to file annual reports disclosing financial income, gifts and reimbursements, property interests, liabilities, transactions, among other information. Specifically, Section 13104 sub A sub 2 sub A of such title requires disclosure of the identity of the source, a brief description and a value of all gifts exceeding minimal value, and Section 13104 sub A sub 5 sub A of such title requires disclosure of a brief description, the date and category or of value of any purchase, sale, or exchange of real property exceeding $1,000. Clarence Thomas, in his conduct as an Associate Justice of the Supreme Court of the United States, engaged in high crimes and misdemeanors by refusing to report the source, description, and value of gifts, and by failing to report the description, date, and category of his sale of real estate property as follows. Good afternoon. Hello. Good afternoon, everybody. Yes, everyone, of course, is welcome, but don't be rude, please, or you will get blocked. All right. Thank you. Hello from Canada. Hello, hello. So let's keep moving on here. Yes, if you're joking, make sure it's clear, because at this point, the people are going after my moderators hard, and so I've given them full authority here. So here we go. Over the course of at least 15 years, Justice Thomas and his wife, Virginia, Ginny Thomas, have received gifts of significant value from Harlan Crow without reporting the source, description, and value of such gifts. Throughout such time, Mr. Crow has served on the board of directors of the American Enterprise Institute, which regularly files amicus briefs in the Supreme Court cases and whose position Justice Thomas has regularly adopted. The unreported gifts include, but are not limited to, non-commercial transportation on a private airplane and on a yacht to and from Indonesia in 2019, valued at approximately $500,000. Non-commercial transportation on a yacht to and around New Zealand in or around 2013. Non-commercial transportation on a yacht to and around Greece in 2007. Extensive free lodging and food at Topridge, a resort in the Adirondacks owned by a company owned or controlled by Mr. Crow. Multiple trips via non-commercial transportation on a private airplane on multiple occasions, including but not limited to flights to New Haven, Connecticut in 2016, to Dallas, Texas in 2018, and again in 2022 to New York City in 2021, and Topridge Resort in New York in 2022, and tuition payments in excess of $6,000 per month to two private boarding schools for Justice Thomas's grandnephew, while his grandnephew lived with Justice Thomas and was in Justice Thomas's legal custody. Justice Thomas failed to disclose a 2014 sale of a single-story home and two vacant lots previously held by Justice Thomas and two family members to Mr. Crow for $133,363, an amount significantly higher than the price of other properties in the neighborhood and significantly higher than the $15,000, the amount that Justice Thomas valued his one-third stake in the properties in 2010. So that's pretty significant. I'm sorry, Atticus is trying to get his little mouse. Let me help you, sweetheart. Here you go. There you go. Go get it. Mr. Crow has also permitted Justice Thomas's mother to continue living in the home rent-free through at least May of 2023 and has paid for improvements for the benefit of Justice Thomas's mother, including construction of a carport. In 2023, Justice Thomas retroactively amended his 2014 report to report the real estate sales transactions involving Mr. Crow, but to date, Justice Thomas has yet to disclose both the free rent and the improvements that constitute additional gifts that Justice Thomas was required but failed to disclose. By accepting but failing to disclose multiple gifts of luxury vacations and travel, Justice Thomas has undermined the impartiality and integrity of the Supreme Court in violation of the public trust. Sticky note, everybody? Do we need a sticky note? Let me grab one here. Here we go. Here we go. Let me grab a marker here. Oh, thank you so much, Stormy. I appreciate that. So these are articles of impeachment for Justice Thomas. Okay, and they're filed today. All right, there we go. You betcha does it, guys. Oh my gosh, I'm sorry. Atticus is really being a bit troublesome over here, so we'll just keep going. Here we go. So, his conduct has caused a reasonable person to believe the gifts were offered. The gifts were offered and accepted in return for being influenced in the performance of an official act and from the same or different sources on a basis so frequent that a reasonable person would believe that he used his public office for his own private gain or for the private gain of his donors. In all of this, Justice Thomas has acted in a manner contrary to his trust as an Associate Justice of the Supreme Court of the United States, to the great prejudice of the cause of law and justice, to the manifest injury of the people of the United States. Wherefore, Justice Thomas, by such conduct, warrants impeachment and trial and removal from office, and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. Article 2, refusal to recuse from matters involving his spouse's financial interest. Oh my goodness. She was thorough so far. The Constitution provides that the House of Representatives shall have the sole power of impeachment, and that all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Section 455 of Title 8 of the United States Code provides that any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. I think this idea of what's reasonable is going to be an interesting debate. Clarence Thomas, in his conduct as an Associate Justice of the Supreme Court of the United States, engaged in high crimes and misdemeanors by refusing to disqualify himself from proceedings in which his impartiality might reasonably be questioned as follows. Justice Thomas participated in the consideration and decision of numerous proceedings concerning entities in which his spouse, Virginia Ginny Thomas, had a financial interest. In 2011, Harlan Crow contributed $500,000 to Liberty Central, an organization founded by Mrs. Thomas, and which in 2010 paid Mrs. Thomas a salary of $120,000. Before, during, and after this contribution, Mr. Crow has served on the board of directors of the American Enterprise Institute, which regularly files amicus briefs in the Supreme Court cases and whose position Justice Thomas has regularly adopted. Between June of 2011 and June of 2012, Mrs. Thomas's firm, Liberty Consulting, received at least $80,000 in consulting fees as part of an arrangement devised by Leonard Leo. Mr. Leo advises a nonprofit called the Judicial Education Project, now known as the 85 Fund, which regularly files briefs before the Supreme Court. Including in 2012, the details of the payment plan were specifically crafted to avoid listing Mrs. Thomas's name on any paperwork. Okay, that might become public. Mr. Leo instructed a for-profit firm, the polling company, to act as an intermediary for billing the Judicial Education Project and then transmitting those funds to Liberty Consulting. The consequence of Mrs. Thomas's financial interest and compensation for entities that regularly file briefs before the Supreme Court or from donors that fund such entities, Justice Thomas has a legal obligation under Section 455 of Title 28, the United States Code, to disqualify himself from proceedings in which those entities participated. Yet, on multiple occasions, Justice Thomas participated in such proceedings anyway. By flagrantly violating federal ethics law, Justice Thomas betrayed his judicial oath to faithfully and impartially discharge and perform his duties under the Constitution and laws of the United States. In all of this, Justice Thomas has acted in a manner contrary to his trust as an Associate Justice of the Supreme Court of the United States, to the great prejudice of the cause of law and justice, to the manifest injury of the people of the United States. Wherefore, Justice Thomas, by such conduct, warrants impeachment and trial and removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. Article 3. So again, we are continuing. Yes, the impact, at this point, we have Justice Thomas, who will now forever have his Anita Hill situation, and now as a Supreme Court Justice who had articles of impeachment filed against him. That is going to be his legacy. Whether it passes or not, I would ask you whether or not it matters if Trump was convicted or not. Refusal to recuse from matters concerning his spouse's legal interest. All right. The Constitution provides that the House of Representatives shall have the sole power of impeachment, and that all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Section 455 of Title 28 United States Code provides that any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might be reasonably be questioned. Clarence Thomas, in his conduct as an Associate Justice of the Supreme Court of the United States, engaged in high crimes and misdemeanors by refusing to disqualify himself from proceedings in which his impartiality might reasonably be questioned as follows. Justice Thomas participated in the consideration and decision of numerous proceedings concerning challenges to the outcome of the 2020 presidential election, in which his spouse, Virginia Ginny Thomas, had an interest. For instance, Justice Thomas participated in the consideration and decision of two cases in which Texas and the Republican Party of Pennsylvania, respectively, sought to induce the federal judiciary to throw out the lawful ballots of thousands of Pennsylvania voters. Not only did Justice Thomas vote to advance these factually baseless and legally frivolous claims, but he also abused his seat on our nation's highest court to promote the falsehood of massive voter fraud and to question the legitimacy of the 2020 presidential election results. And we're citing the Texas case here. And I was wondering if someone was going to pull this in. So we've got Alito dissenting from denial of leave to file a bill of complaint, joined by Justice Thomas. And then we've got the further complaint here. Thomas dissenting from denial of certiorari. Justice Thomas also participated in the consideration and decision of proceedings concerning the insurrection of the United States Capitol on January 6th of 2021. Proceedings in which Mrs. Thomas had an interest. On December 23rd of 2021, Donald Trump submitted an emergency application for a stay and an injunction to Chief Justice John G. Roberts, seeking to prevent the National Archives from releasing records concerning Mr. Trump's attempt to overturn his defeat in the 2020 presidential election to the House Select Committee to investigate the January 6th attack on the United States Capitol. Chief Justice Roberts referred Mr. Trump's application to the full Supreme Court. These records included communication by White House Chief of Staff Mark Meadows, because Mr. Meadows had been texting with Mrs. Thomas on or around January 6th of 2021. It is possible that these records included text between the two of them. On January 19th of 2022, the court denied Mr. Trump's application, refusing to block the release of the records in Trump versus Thompson. Not only did Justice Thomas take part in the consideration and decision of that proceeding, but Justice Thomas was the only justice who indicated that he would have voted to grant Mr. Trump's application. As part of the same litigation, Mr. Trump petitioned the Supreme Court for a writ of certiorari, asking the court to reverse the decision below, refusing to enjoin the National Archives from turning over these records to the Select Committee. The court denied Mr. Trump's petition. Again, Justice Thomas participated in the consideration and decision in these proceedings. Justice Thomas's impartiality in the aforementioned proceeding might reasonably be questioned because Mrs. Thomas actively participated in contemporaneous political and legal efforts to overturn Mr. Trump's defeat in the 2020 presidential election. Indeed, Mrs. Thomas's interest in the outcome of these proceedings, from the article, hello, thanks, Daniel, throughout thoroughly and promised Justice Thomas's impartiality in any case challenging the results of the 2020 presidential election or concerning the events of January 6th of 2021. In the weeks between the presidential election on November 7th of 2020 and the violent insurrection at the United States Capitol on January 6th of 2021, Mrs. Thomas repeatedly urged then President Trump to illegally overturn the election results and advised Mr. Trump on his litigation strategy, including in an exchange of at least 29 text messages about the election with the White House Chief of Staff, Mark Meadows. Oh my goodness gracious. Mrs. Thomas advised the president to initiate and sustain political, legal, and extra-legal attempts to overturn the results of the 2020 presidential election, writing, quote, "do not concede," end quote. Quote, "the majority knows Biden and the left is attempting the greatest heist of our history," end quote. And quote, "save us from the left taking America down," end quote. Mrs. Thomas advised then President Trump on discrete litigation decisions, for instance, urging him to promote and retain Sidney Powell as his lead attorney on these matters, writing, quote, "don't let her and your assets be marginalized. Instead, help her be the lead and the face," end quote. Quote, "sounds like Sidney and her team are getting inundated with evidence of fraud. Make a plan, release the Kraken," end quote. Mrs. Thomas advised then President Trump's chief of staff on how to manage the president's legal team, for instance, directing him to confer with and defer to particular attorneys and advisors, writing, quote, "listen to CLEDA," end quote, and to improve their morale, writing, quote, "suggestion, you need to buck up your team on the inside, Mark," end quote. Mrs. Thomas liaised between the White House and the president's personal legal team and other possible participants in the president's attempt to overturn the results of the 2020 presidential election, like Jared Kushner and the office of Representative Louis Gohmert, writing, quote, "just forwarded to your Gmail an email I sent Jared. This Sidney Powell and improved coordination now will help the cavalry come and fraud exposed and America saved," end quote. And Mrs. Thomas advised the president to pursue his unlawful aims by any means necessary, suggesting that he disregard his legal and ethical obligations in the pursuit of the aims of the attempt to overturn the election, writing, quote, "the most important thing you can realize right now is that there are no rules in war," end quote. Oh my goodness. Throughout this exchange, the president's chief of staff engaged with and embraced Mrs. Thomas's legal and political advice, confirming Mrs. Thomas's status as a trusted participant in those decisions. Oh my goodness. When Justice Thomas participated in the consideration and decision of the aforementioned cases concerning the 2020 presidential election and the insurrection at the United States Capitol on January 6th of 2021, he knew or should have known his spouse's participation in the attempt to overturn the results of that election. Mrs. Thomas implied to others that she had told Justice Thomas herself. After the White House Chief of Staff urged Mrs. Thomas to maintain her commitment to this, quote, "fight of good versus evil," end quote, that is, overturning the results of the 2020 presidential election, she replied that she was encouraged by, quote, "a conversation with my best friend just now," end quote, using a phrase, quote, "best friend," end quote, that she and Justice Thomas publicly used to refer to one another. Even if Mrs. Thomas did not directly inform Justice Thomas of her participation, much of Mrs. Thomas's work to overturn the result of the election was a matter of public record as she performed it. Justice Thomas of her participation, much of Mrs. Thomas's work to overturn the result of the election was a matter of public record as she performed it. 9 members of the Board of Counsel for National Policy Action, attending that rally and signaling a public letter alongside prominent far-right leaders urging House Minority Leader Kevin McCarthy to expel 2 House Republicans in retaliation for their service on the Select Committee investigating the insurrection. In the exceedingly unlikely event that Justice Thomas was unaware that his spouse was privately and publicly working to overturn the results of the 2020 presidential election, he was derelict in his legal and ethical duties to know. Federal law required him to make a reasonable effort to discover a fact so obviously relevant to his role as one of the final arbiters of litigation about the election. Section 455 sub C of Title 28 United States Code is explicit that Justice Thomas has a duty to inform himself of his spouse's interests. In consequence of Mrs. Thomas's collaboration with then-President Trump to overturn the results of the 2020 presidential election, Justice Thomas had a legal obligation under Section 455 of Title 28 United States Code to disqualify himself from proceedings concerning that election and the endeavor to overturn it by litigation, force, or fraud. Yet on multiple occasions, Justice Thomas participated in proceedings concerning the election anyway. By flagrantly violating federal ethics law, Justice Thomas betrayed his judicial oath to faithfully and impartially discharge and perform his duties under the Constitution and laws of the United States. In all of this, Justice Thomas has acted in a manner contrary to his trust as an Associate Justice of the Supreme Court of the United States, to the great prejudice of the cause of law and justice, to the manifest injury of the people of the United States. Wherefore, Justice Thomas, by such conduct, warrants impeachment and trial and removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. Hello, Bobby. Yes, so there we go. We've got those articles of impeachment now filed on the floor. Again, not on the floor, I apologize. When I say filed, it doesn't immediately go to the floor, of course, unless it's called to the floor. There's procedures that we go through involving committees and various things, but they've been filed. So we do have this filing. So that's something at least, okay? I would remind you that, again, we do not have a conviction by any means, and we haven't gone forward, but the filing in and of itself is a historical moment, absolutely historical moment. So what's going to happen now is that everybody is going to be talking and going through and trying to figure out what's true and what's not true, and whether or not it rises to the level of high crimes and misdemeanors. So I think that this is incredibly valuable in order for us to have this discussion. Now, with that, let's move on to the second set of articles of impeachment for Justice Alito. If everyone is ready here, I'll make a new sticky note. It may not go anywhere, but sometimes the end isn't where the damage is. Sometimes the damage is through the process. So we will see. Right, we will see. So, yes, let's head on to the articles here for Justice Alito. So we have articles of impeachment. I mean, this is pretty huge, everybody. It's pretty huge. I mean, if it doesn't get passed, whatever, but the filings with appropriate information filed to it is pretty major. And then we have Justice Alito, who is the one who wrote the Dobbs decision. Justice Alito here. And again, this was filed just today. So here we go. We'll dive right in. Well, Dave, you can have your own opinion, but as an attorney for Supreme Court Justice to have articles of impeachment filed, it's pretty huge. Right. It's a pretty huge deal. All right. Here we go, everybody. Here we put AOC on the Post-it. Is that helpful? Can the cases be reopened? Yes. who filed them. So I don't think I am going to, because this particular representative has had assassination threats against her. So I think I will leave her name off of the sticky note, everybody, and just leave it to people who are interested to look it up. So we'll just kind of leave it that way. Yes, she is probably the single most threatened representative. Mm-hmm. Yes, I agree. Yes, yes. I think if it was right. Thank you, Cozy. Yes. All right. Well, let's go ahead and dive in, and then we'll do a Q&A, everybody. All right, and kind of go through the importance. Thomas, I just finished Thomas's. I do request everyone please be respectful. My moderators are working very hard, and I appreciate their hard work, so please be respectful of their requests. I appreciate it. I'll switch the page. We just have one paragraph here, and then I will switch the page. Yep, we'll switch it over here. All right, here we go. Resolution impeaching Samuel Alito, Jr., Associate Justice of the Supreme Court of the United States for high crimes and misdemeanors. Here. Yes, and to the moderators, for any of those blatant, if any of them get threatening, to just take a screenshot, send it to me so that I can add it to the file of threats. All right. Thank you very much. Resolved, that's Samuel Alito Jr., Associate Justice of the Supreme Court of the United States, is impeached for high crimes and misdemeanors, and that the following articles of impeachment be exhibited to the United States Senate. I'll go through that, Adam, after I finish this one up. Excellent question. Articles of impeachment exhibited by the House of Representatives of the United States of America in the name of itself and of the people of the United States of America. The trolls are coming in, everybody, so just beware. You can get rid of the comments if you don't want to see them on your screen. Against Samuel Alito, Associate Justice of the Supreme Court of the United States, in maintenance and support of its impeachment against him for high crimes and misdemeanors. Article 1, refusal to recuse from cases in which he had a personal bias or prejudice concerning a party. The Constitution provides that the House of Representatives shall have the sole power of impeachment, and that all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Section 455 of Title 28, United States Code, provides that any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. On January 31st of 2006, when Justice Alito assumed his role in the Supreme Court, he took 2 oaths of office, a constitutional oath and a judicial oath of office. When taking the constitutional oath codified as Section 3331 of Title V, United States Code, Alito promised to support and defend the Constitution of the United States against all enemies, foreign and domestic. When taking the subsequent judicial oath codified, Section 453. How are we doing, VC and Cozy? Do I need to turn off comments? I can turn them back on for a Q&A. Are we inundated? Are we infested? Let me know. Do I need to turn off comments? We're good. Okay, thanks. Just double checking. We're okay. Okay, excellent. All right, so when taking the subsequent judicial oath codified at Section 453 of Title 28, United States Code, Alito promised to faithfully and impartially discharge and perform all the duties incumbent upon me as an Associate Justice of the Supreme Court under the Constitution and laws of the United States. Samuel Alito, in his conduct as an Associate Justice of the Supreme Court of the United States, engaged in high crimes and misdemeanors by refusing to disqualify himself from proceedings in which his impartiality might reasonably be questioned as follows. In January of 2021, Justice Alito allowed an upside-down American flag to be flown outside his primary residence for several days. At the time, an upside-down American flag was widely understood to be an expression of support for the criminal efforts to overturn the results of the 2020 election and was a symbol displayed by those who attacked the Capitol on January 6 of 2021. an event that occurred only shortly before Justice Alito allowed the flags to be flown outside his residence. By displaying this flag, he showed support for domestic enemies of the United States. Wow, that's really powerful, everybody. Wow, that sentence is incredibly powerful. Let's just highlight that for a moment. Some of whom engaged in an insurrection at the U.S. Capitol building in violation of his constitutional oath of office. In summer of 2023, by allowing a flag associated with the criminal efforts to overturn the results of the 2020, can you read it again? Absolutely. By displaying this flag, he showed support for domestic enemies of the United States. I think that's really important. That's a really important line. All right, so overturn the results of the 2020 election, and with a partisan faction of a political party to be flown outside of his secondary residence for several months. Justice Alito's behavior showed a lack of impartiality as required by his judicial oath of office, thereby undermining public confidence in the integrity and impartiality of the judiciary. According to Section 455b1 of Title 28 United States Code, a justice of the Supreme Court, like any judge, must recuse for matters in which he has a personal bias or prejudice concerning a party. Separately, Section 455A of such title requires recusal in circumstances that his impartiality might reasonably be questioned. Justice Samuel Alito's failure to recuse in Trump versus United States, Fisher versus United States, and Trump versus Anderson violates both provisions of Section 455 and serves as a legal bias for impeachment. And I just will say at this moment, everybody, without a doubt in my mind, I feel as though the law of precedent and res judicata was not followed properly by the U.S. Supreme Court in all three of those cases. Trump versus United States, a Supreme Court case about the preservation of a functioning democracy, asked the question of whether a former president is entitled to absolute immunity from criminal prosecution for actions within his constitutional authority. The case arose from charges filed against Donald J. Trump for his role in inciting an insurrection in an attempt to stop the certification of votes following the 2020 election. Fisher versus United States asked whether the Section 1512C2 of Title 18 United States Code, a provision of the Sarbanes-Oxley Act, can be applied to the insurrectionists who stormed the Capitol building on January 6th of 2021 in order to attempt to stop the certification of votes following the 2020 election. Trump versus Anderson asked whether a state court could enforce Donald Trump's disqualification from office for engaging in insurrection against the United States Constitution, where he incited the January 6th insurrection at the Capitol building and disrupted the transfer of presidential power in violation of Section 3 of the 14th Amendment. By repeatedly, over a period of multiple years, flying flags associated with the attempt to overturn the election results and stop the peaceful transfer of power, Justice Alito publicly displayed a bias towards those who incited and executed the January 6th insurrection. Because Justice Alito engaged in a pattern of declaring sympathy with the parties before the Supreme Court in Trump, Fisher, and Anderson, Section 455 of Title 28 United States Code required Justice Alito to recuse from all matters related to the insurrection. Section 455 of Title 28 United States Code does not require an investigation into the heart and mind of individual justices. Subsection A of such section requires recusal whenever a justice's impartiality might reasonably be questioned, since a Stop the Steal symbol first flew on a flagpole outside Justice Alito's home. It has been reasonable to question Justice Alito's ability to impartially adjudicate matters related to the January 6th insurrection. The proper functioning of the United States Supreme Court depends on justices' commitment to impartiality in both fact and appearance. By disregarding his impartiality and aligning himself through public conduct and statements with the insurrectionary cause, the laws of the United States require Justice Alito to recuse himself in Trump v. U.S., Fisher v. U.S., and Trump v. Anderson. failure to comply with subsection A and subsection B1 of section 455 of Title 8 United States Code by refusing to recuse in Trump v. U.S., Fisher v. United States, and Trump v. Anderson, each of which concern the attempt to overturn the 2020 election by interfering with a joint session of Congress to certify the election on January 6 of 2021, is cause for impeachment for high crimes and misdemeanors. Justice Samuel Alito has engaged in a pattern of conduct that's incompatible with the trust and confidence placed in him as a justice of the Supreme Court by failing to disqualify himself from cases in which he had a personal bias or prejudice concerning a party. Section 455 of Title 28 United States Code provides that any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned, or if he has a personal bias or prejudice concerning a party. Justice Alito has indicated sympathy with the efforts to overturn the 2020 election by allowing symbols of support for those efforts to be flown outside his residences. Contrary to the clear dictates of federal recusal statute, which requires disqualification if a justice's impartiality might reasonably be questioned, Justice Alito did not recuse himself in Trump v. United States, Fisher v. United States, and Trump v. Anderson, all of which concerned the attempt to overturn the 2020 election by interfering with a joint session of Congress to certify the election on January 6th of 2021. In all, Justice Alito betrayed his constitutional oath to support and defend the Constitution of the United States against all enemies, foreign and domestic, and his judicial oath to faithfully and impartially discharge and perform his duties under the Constitution and laws of the United States. Wherefore, Samuel Alito Jr., by such conduct, thus warrants impeachment and trial, removal from office, and disqualification to hold and enjoy any office of honor, trust, or profit in the United States. Article 2, failure to disclose. All right, so we've got our first piece. Let's look at the second piece here. The Constitution provides that the House of Representatives shall have the sole power of impeachment, and that all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Section 13103 and 13104 of Title 5. The United States Code requires judicial officers, including associate justices of the Supreme Court, to file annual reports disclosing financial income, gifts and reimbursement, property interests, liabilities, transactions, among other information. Specifically, Section 13104 sub A sub 2 sub A of such title requires disclosure of the identity of the source, a brief description, and the value of all gifts exceeding minimal values. In Section 13104 sub A sub 5 sub A of such title requires disclosure of a brief description, the date, and the category of value of any purchase, sale, or exchange of real property exceeding $1,000. Again, I'm watching out for the puzzle piece, everybody, so forgive me if I'm a little bit stilted here. Justice Alito has engaged in a pattern of corrupt conduct that's incompatible with the trust and confidence placed in him as a justice of the Supreme Court by accepting in front of corrupt conduct that's incompatible with the trust and confidence placed in him as a justice of the Supreme Court by accepting in front. Justice Alito did not disclose the gift in his financial disclosure reports as required by Ethics in Government Act, and repeatedly chose not to recuse himself from hearing cases in which the wealthy individual had direct interest in violation of Section 7353 of Title 5 of the United States Code. By failing to disclose the gift of luxury travel and failing to recuse from hearing cases affecting the donor's business interests, Justice Alito has undermined the impartiality and integrity of the Supreme Court in violation of the public trust. His conduct has caused a reasonable person to believe the gift was offered and accepted in return for being influenced in the performance of an official act, and on a basis that would cause a reasonable person to believe that he used his public office for his own private gain or for the private gain of the donor. In all of this, Justice Alito has acted in a manner contrary to his trust as an associate justice of the Supreme Court of the United States, to the great prejudice of the cause of law and justice, to the manifest injury of the people of the United States, Wherefore, Justice Alito, by such conduct, warrants impeachment and trial and removal from office and disqualifications to hold and enjoy any office of honor, trust, or profit under the United States. So there we go. There is our set of articles for Justice Alito. All right, so let me pull these out here so we can see both sets that were filed. So we have articles of impeachment here. And then we also have our second set of articles down here. Thank you for bringing the truth. Oh my goodness, my pleasure, my absolute pleasure to do that. I wish I could have brought them to you a bit sooner, but it took me a little bit of time to track everything down and make sure it was filed. So great news. Yes, I agree. I love it when it's simple. Well, right. I mean, it doesn't have to be complicated. It doesn't have to be too complicated. We don't know what's going to happen, right, everybody? We just don't know because just because something is filed doesn't mean that it's been agreed upon. We have to go through the normal process of having, discussions in Congress and getting enough votes in order for it to actually be passed, which could be quite difficult. But although these days it's hard to tell. It's hard to tell exactly. So let me just pull up where we have the articles of impeachment or impeachment powers in Congress. So let me just see here. Thank you. Oh, yes, you're welcome. Of course. I'm sorry, everybody. I'm looking through Article 2 here. Right, Journal of Proceedings here. All right, so Article 1, Article 2, right, vacancies, Article 3. So the Senate shall have the sole power to try all impeachments when sitting for that purpose. They shall be on an oath or affirmation, right? So then we need to pull back and take a look here. House of Representatives, apportion. Sorry, everybody. I'm just trying to check and find the exact language here. You're welcome, H. Titus. You're welcome. Each house will keep a journal. I'm just not sure. I'll have to keep looking, everybody. Congress shall have the power to lay and collect taxes. Every order resolution needs a concurrence. Right. So I'll have to keep looking through here. We've got a few different pieces in the Constitution regarding impeachment, but writ of habeas corpus, bill of attainder, tax and duty here, no money, title of nobility, no state shall enter, no state shall enter. Well, I'll have to take a look. I'll keep looking, everybody. But yes, the articles of impeachment go through the House of Representatives. If they are passed, then they do go over to the Senate for a trial. And the only mention of who presides as the judge is if there's a trial for the president. We have had federal judges who've been impeached before and have had trials. I'm not sure exactly how they've run. In fact, I just read articles of impeachment for, I believe, a federal judge in 2010, but it was just a federal judge. But we do have procedures that we have to follow with that. But this is the way you remove a lifetime appointed judge, is for high crimes and misdemeanors. So let me just double check. Yeah. Can you say what Alito didn't do right on some cases? It's a good question. I would say, and I agree completely with where she's coming from. Whether it's enough to convict, that I don't know. but I hear where she's coming from. The issue with Justice Alito on the cases was having a financial interest in companies and people that were in front of the court. He didn't recuse himself, which is like the number one no-no. Number one and number two, conflicts of interest and failure to recuse are huge no-nos. And so what she's saying is that he had this kind of a relationship or a relationship that was enough that he should have recused himself from cases. Two at once, yes, indeed. I mean that it is historical. It is historical. It's enormous. Now, again, what will happen? We have to go through the proper procedures. But what we have here is we have the legislative branch of the government doing their job of checking the judicial branch. They're saying the judicial branch is out of line. Now, whether or not the people who have been elected to Congress agree on the articles of impeachment and then agree to convict, that's something else. That's up to the elected representatives and senators to decide. But the filing of these articles are allowable, and it's what was meant by how it was originally written in the Constitution. Yes, right. Articles of impeachment. They have not been, these have just been filed, all right? They've just been filed. We do not have approval here from everybody. They've not been confirmed. So we do not have a confirmed impeachment. We just have articles setting out what they believe to be impeachment-worthy high crimes and misdemeanors. And if the Democrats take the House, right, and 30% of the Senate's up again. You're welcome, Sloan. Constitution states as long as they're in good behaviors, they're quit. Right, and good behavior means they cannot be part of high crimes and misdemeanors. That's good behavior specifically goes to that premise. Do you think the House will just drag this out? Hard to know. Who impeaches Judge Cannon? Good question, and I think it would be the House. Honestly, it looks like the House of Representatives is the one that would do any articles of impeachment for any U.S. federal judge that is lifetime appointed would go through the House. I'm not, and again, everybody, I don't know what's going to happen, but the fact that they were filed is historic. It's monumental. 2 U.S. Supreme Court justices with articles of impeachment set out, and not just for, yes, we've got some really bad things here with Justice Thomas and his wife. That's pretty hardcore. But we've got this idea over here with Alito. He was sympathetic, but we're not just dealing with that. We're dealing with actual financial failures to disclose finances, and that's huge. That's where you get into just a numbers game. That's instead of having, I guess I look at it kind of like the DC case where, the big thing is like, was there a violation of civil rights? Well, we'll take a look and see versus the Florida case where it's just a documents case. So she set out here, not just, civil rights violations or a violation of your oath because of your bias. She also set out a set of, she's like, look at the paperwork, look at the numbers and see what happens. Again, this has not been decided on, but that's what she is proposing here. Right. The House impeaches and the Senate convicts. Friendly reminder on Trump's second impeachment, there were 6 senators that were short for the conviction. 6 senators. Why not Roberts and Kavanaugh? Good question. And I think it's because, honestly, there isn't the paper trail. We don't have a documents issue going on with them. We don't have taxes and failure to disclose issues like we do with these 2. So there are reports coming out with these 2 regarding the amount of money that they've been given. Of course, Thomas is way ahead. But Alito has some issues too going on with the amount of gifts he was given. They've also been on the bench the longest. So, Roberts may have an issue down the road if more information comes in. Will this expire? So it goes through the normal process of how any of our laws go. So it's going to have to get enough votes to be heard and whether or not it's argued on the floor or not. So it goes through the normal process. This isn't something that, has to be done within a certain period of time or else it's over. What happens is there has to be enough votes to keep it moving down the river is how that goes. Am I going to write a book? I don't know. I might. I might write a book on, my color coding system. I don't know. Oh my gosh, that's so funny. Work for Congress, I had to donate flowers. Someone sent me, oh, I know. Well, that's exactly right, Annie. I mean, that's the thing is, the Supreme Court justices when in doubt, just say, oh, it was just a gift. But on the other hand, there's bare minimum requirements, dudes, and they might say, well, Ginsburg did this and Ginsburg did that. Well, she's not on the court anymore. You guys are on the court. You gotta do it properly. You gotta do this right. Invaluable. Oh, thank you so much. Can Johnson stop this from going to the floor for a vote? It's all about how many votes you get in order to move it through the process. You have to get enough votes to move it through the committee, to move it through out to the floor. There can be a situation where a representative can call for an immediate vote, but there's all kinds of, rules that go on. You just have to follow the normal rules. So Johnson would be part of, the gathering of votes. So he's technically one vote, but his influence is enormous, I guess is how I would put it. I need 218. I know. Can only get $50 gifts a year. I know, and that's a lot. And come on. We had, who was it that had the Botox? And it's you're out, man, for getting your Botox. It's different, but still. The premise, of enriching yourself on somebody else's dime incorrectly is still there. You're welcome, Jessica. My pleasure. Brought the flowers to a nursing home. Oh, that's so sweet of you. Yeah, you got to be careful. I remember when I worked for my state house, and I was working with a representative, and he was asking for, I can't remember now, it was a long time, everybody. He was asking for mints or gum. And I was like, well, here, I have some. And he's like, I can't take it. That'd be seen as a gift. And I was like, all right, well, go get your own gum. I'll be here when you get back. Right. Well, and that's the thing is this going to happen? We don't know. But now the questions are out there, and we have a path forward. The questions are raised. We're not going through this with everyone just saying, well, nothing can be done, so I guess we won't do anything. We actually have something going forward. I know, right? After that, I was like, oh my gosh. Hope you remembered your mints, dude. Oh my gosh, that's one thing you don't realize. If you ever work in an elected place like the Senate or the House, everybody's chomping constantly on mints. And you're like, well, that's weird, but it's because they're talking to people so much. So, people are just like, well, I just gotta make sure, you get hooked on them and you can't turn back. That's a little insight into working in an elected position, just so you know. Right. I know. Everyone's like, mints. Emotional state is I know. It's frustrating, everybody. You have to have something to drink. Yes, exactly. Oh my gosh, no, you can't do that. So I'm not sharing at this point who filed these. I did share at the very top of the hour here, but at this point I'm just kind of leaving it because I've noticed a huge number of people asking because this particular representative has had so many threats and assassination attempts against her and was really singled out also to be harmed. So I'm not going to mention her name, but I will say you can pull these up online. They are public documents. You can, of course, talk about it here in the comments if you so wish. Absolutely, that's up to you. And they are handily available. So it really is Dora. She, I think, is one of the top most threatened of all of them. She's from Brooklyn, true, but yet no woman should have to go through what she has gone through. So thank you, VC. They're in your link tree. Excellent. Whether it goes or not, a happy day. I agree, Lex. I agree. Again, whether it goes or not. Now, we got to talk about this articles of impeachment that have been filed, all willy-nilly. But if you read those articles of impeachment, and I have, you look and see, well, what facts do you have to back them up? And, I think that's important. I think what she's saying here regarding the situation is important. What she's saying about non-disclosure and what she's saying about what she thinks is a reasonable person bias? I think it's good to know. Post it on Instagram. Oh, we love it. We love it. Full support for someone. This is huge, right? We've got this woman, and there's nobody else on these articles, everyone. This is just her standing up against the United States Supreme Court. I mean, of course, she's not been shy about it in the past, but she, actually pulled it, went forward and filed this. I think that's pretty enormous. Facts are important. That's right. And, until we get to the end of it, we don't have all of the facts. We've got some very interesting information. I would say with these articles, it leads me to believe that more information is needed. I feel like this is smoke and we need to look for the fire. Maybe there's not a fire, but maybe there is. So that's what we would put in here. This would lead me to believe we've got reasonable suspicion to believe that criminal activity is afoot. This would be enough for a stop and frisk. All right. That's what I'm saying here. This is enough for a stop and frisk. Is it enough for a grand jury indictment? I don't know. Is it enough for a conviction? No, but it's enough for a frisk. I would say this is frisky. Well, maybe it won't. It won't, but I think it's valuable. It's enough for a stop and frisk. We need to be stopping and frisking these two justices. All right. Oh my goodness. Oh, thank you. That was really beautiful, Shadow. I appreciate that. Oh, so pretty. Yes. So it's a big moment. Historically, again. So I think that's important. It'll shake things up. Exactly right. She make those claims without proof. Exactly. But we go forward. There's a process. We follow the rules, and we have rules for a reason. We're supposed to follow the rules. But when people have too much power and don't follow the rules, things like res judicata, then it's time to call them out and be like, hey, there's some problems here. History will show the truth. It certainly will. And the fact that we can all, come together and talk about it too. So we'll definitely have something. Yes. And I tell you what, Lisa, the Citizens United Amendment has been discussed for multiple years. Did everybody know that there's actually a proposed Citizens United constitutional amendment? So there has been that put together, a full amendment that would completely overturn that decision. But, you got to have enough votes in order to get it going. So, again, voting's very important, everybody. Very important. Super important, everyone. Vote. I would say. So with that, everybody, I do want to remind everyone I will be back again tonight, just in a couple of hours, actually, at 6:00 Central, so in about 3 hours. And I will be getting us back onto the Trump train when it comes to the different trials. We will be going into Florida and looking around and seeing what's going on there and, resetting our calendars here. We've got a couple of things we need to shift around. So we will be talking about that later tonight. So, yes, don't forget the local elections, absolutely. So I will be back again in a couple of hours. I hope you all can come and hang out, and we'll go through the Florida docket such that it is, and kind of do a Q&A on what's going to be going on in that case. So, sadly, yes, it has been postponed, but that's okay. That's all right. I mean, that sometimes happens. So we'll get it sorted out one step at a time, everyone. So thank you all for joining me for this impromptu articles of impeachment. Again, they've not been passed. They've been filed. So have a great rest of your day. And for those of you coming back in a couple of hours, I'll see you in a couple of hours. Take care.